was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution, and here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi, and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleagues' submissions where they say you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance, of the scale. On the other, you have a sitting deputy president who is before a court of law, as he ought to be. If, in the unlikely event, his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. What former Supreme Court Judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush. to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gatirau Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gatirau Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleague,